Good afternoon. This is a hearing of the Bethany Beach Board of Adjustments for the purpose of considering an application submitted by Michael and Ann O'Reilly, the property owners, for the property identified as Block RH31, Lot 2 at 619 Holly Court in the R2 Residential Zoning District of Bethany Beach, Delaware. Applicants seek a variance from Chapter 425 zoning, Appendix 3, Table of Dimensional Requirements, minimum yard depth, side, for an existing encroachment of 1.9 feet into the westerly side yard. Let the record show that all of the 5 members of the board are present. I ask that each of the board members speak his or her name for the record at this time in order to facilitate identification of voices in preparing the transcript of this proceeding. My name is Michael Loftus.
Jack Gordon.
My name is Sherwin Weinstock.
My name is Steve Boyce.
My name is Tempe Steen.
Susan Frederick.
In addition to Susan, the town's building inspector, we have Raylene Menominee, the clerk to the board, seated at the desk in the rear. The application and associated documents are part of the record and have been marked as Appendix 1. Before we begin the hearing, the board would like to welcome Tempe Steen as a new member. She was appointed by the town council on April 19th, and this is the first proceeding she has participated in. She is an experienced and accomplished attorney with substantial expertise in issues arriving before the board. We welcome her and look forward to working with her.
Thank you very much. It's nice to be here.
We'll now proceed with the hearing in this matter and begin by addressing the publication requirements for the hearing. Susan, do you swear or affirm to tell the truth in this proceeding?
I do.
Was notice of this hearing posted in a public place?
Yes.
And when and where was that done?
Posted on 5/13/2024 at Town Hall, twice at the bandstand, the post office, and the library.
Was notice of this hearing published by the town?
Yes, it was published in the Wave newspaper, May 14th, 2024, the Coastal Point newspaper on May 10th, 2024.
All right. And was notice by mail sent to property owners within 200 feet of the subject property?
Yes, notice was mailed 5/13/2024.
And lastly, was notice posted on the property itself?
Yes, the notice was posted on 5/13/2024.
In the absence of objection, I find that notice of this meeting has been posted and published consistent with Section 425, Part 107 of the Code. As we proceed with this hearing, all testimony will be sworn. Participants, once sworn, remain under oath until we finish the hearing. We'll begin with a synopsis of the application by the town building inspector, followed by questions from the board members, and identification of parties, those wishing to make a statement. They will have a presentation of applicant's evidence, then presentation of any opponent's evidence. At the closing of all evidence, I should say there will be an opportunity for those who wish to express support for the application. Is anyone here planning to address the board to express support for this application? I see none. Is anyone here desiring to oppose the application? I see none. Finally, the board will deliberate and may vote if we finish deliberations today. I have no doubt that we will. Such a vote is only to be considered part of a preliminary deliberation. The final decision approved by a majority of the board is the official position and decision of the board. I might say in that connection that we are and have been conscious of your desire for expedition given the circumstances. The notification requirements of the code and availability of people dictated this as the earliest date we could address this. But I think we will be able to deliver a written decision expressing the outcome in short order. Susan, could you describe your memorandum to the board?
You know, all right, this is Board of Adjustment Case 2024-3 for 619 Holly Court, Lot 10, Block 31, RH 31, for Michael and Ann O'Reilly. The applicants are requesting a variance for an existing encroachment of 1.9 feet into the left westerly side yard. Pursuant to Chapter 425 zoning, Appendix 3, Table of Dimensional Requirements, the required side yard setback in the R2 residential district is 7 feet. The property is zoned R2 and is an irregularly shaped lot at the end of a cul-de-sac in the community Bethany West. It is improved with a one-story single-family dwelling that was constructed by the applicants in 1987. There is a certificate of occupancy on file issued December 21, 1987. A second permit for a deck was issued in May 1988. The survey on file from February 2nd, 1988 shows that the left side of the lot is comprised of 3 intersecting segments and shows a dimension of 7 feet on the left side at the intersection of the 2 segments of the property lines to the edge of the dwelling. The original survey did not show the setback lines on the survey. A current survey being prepared determined that when the lines designating the required setbacks are properly shown on the survey, the lines connect at a point within the footprint of the dwelling. A triangular portion of the dwelling encroaches into the side yard, the maximum width being 1.9 feet. Due to the circumstances, an administrative variance was considered. However, per Section 425-105E, an administrative variance may only be considered and granted for existing conditions of 12 inches or less. And copies of the code were attached, as well as the application and the certificate for occupancy, and surveys were found in the applicant's submittal. Any questions?
I have no questions.
No question.
I think
question.
I think I do. What is the town procedure on building permits? No, I've been to one Board of Adjustment meeting here in the last so many years. Does the town do any measuring, or do you rely on surveys?
Well, this was done in 1987, and I'm pretty sure they didn't measure anything then. We don't measure. We accept surveys sealed by the professional surveyor.
And if a variance were to be granted for this 1 foot 9 inches, is that limited to the existing structure corner that is encroaching?
Yes.
Okay, thank you.
No questions.
Mr. O'Reilly, will you be speaking for the applicants? Would you please approach the podium? Please state your full name and your local address for the record.
Michael O'Reilly, 619 Holly Court, Bethany Beach.
Do you swear or affirm to tell the truth in this proceeding?
I do.
Thank you. Please proceed.
Thank you. I have to say it's a little odd for me to be on this side. I'm an attorney. We live in the town of Herndon, and I've spent 15 or 16 years sitting on our local architectural review board, our heritage board, our planning commission, our town council, and I was able to serve one term as mayor. And so I think it's been 20 or 25 years since I've been in front of a group like you, but let me tell you this, thank you for hearing us on relatively short notice as quickly as you were able to. We're in a little bit of a bind, and we're happy that we were able to be here. And thank you for your service to the town. I can say in the audience today is one of the purchasers who's scheduled to close with us now on July 1st, assuming that we're successful today. And they're very excited, and thank you as well that you were able to hear us. As far as the application, we did submit an application with a number of exhibits, and I don't want to read that. I'm sure that you all have had it in your packet. But basically what happened was in the Coffin survey in 1988, a mistake was made on the location of the house that we've had for the last 36 years. It says it was 7 feet 5 inches from the boundary line, when in fact the new survey shows that it's closer, and that's what gave rise to the 1.9 encroachment into the side yard setback. We were 3 days before closing to the previous buyer when we learned of this, and the previous buyer was anxious to get into the house and wasn't able to wait for the process to take care of the problem and didn't want to take on the problem themselves. So that contract fell through, and we were blessed to have the new contract. As you look at it, as you all know, what you need to decide are the factors that you have to consider. And they're actually set out, I believe, in the ordinance. And the four important ones, as I understand it, the first one is that there have to be extraordinary, exceptional conditions regarding essentially the shape of the lot. And in our case, it is an irregularly shaped lot, and as I pointed out in the memorandum that we submitted, or in the letter we submitted, the lot line takes a sharp turn right at the midsection of our house. And in fact, if on lot 11, if that house was located on this plat, it would be kind of on the same line as our house, so they would be symmetrical. Our backyard goes right through his backyard. So as we walk through our backyard to the what's on the left side of the map, we're walking right behind his back screen porch. And God bless Fred and Mildred Leonard, who own that property, and we're understanding of where the limits are. The reason I think the lot was designed like that is because, as you see on that plat, the earlier plat, the Assawoman Canal runs directly at that edge through some woods, but the lot was designed so that we would have access, and we've enjoyed that access for the last 36 years. So it's an irregularly shaped lot. Would there be an injustice or a hardship to the owners? It was 36 years ago. We didn't know about this until just a couple of months ago. In order to remedy the situation, we would have to likely try to go back to the builder, Nanticoke Homes, who went bankrupt in 2002, or Joe Riskowskis, who was our lawyer at closing in 1987, which couldn't be just absolutely couldn't be done. I have no idea what it would cost to move the house and the foundation, 1 foot 8 inches. But to say it's an unnecessary hardship, I think, would be an understatement. The next thing that you all need to look at, is it peculiar to the property? There may be other instances somewhere in town where someone encroaches 1.9 inches in the setback. I'm certainly not aware. If you all are, that's fine, but it is peculiar to this property, that side yard setback violation. The next, would it cause detriment to the public good? I can tell you from the number of people that I've spoken to about a 1'9" side yard setback, and that we had to come to a variance hearing, they feel like it's been a detriment to the public good that we had to do this. Not that granting it would do it, but granting it would help solve the problem, and it wouldn't impact the public good whatsoever. And finally, is there some negative impact on the owner? And I've already described the problems that we would have if the variance is not granted. Clearly, it would be, there would be a negative effect on the owner. So I think when you look at how to apply the code to the situation that we have before us, you'll agree with us that the variance should be granted, and you'll grant it. I'll be happy to answer any questions about the property or anything else if you all have any.
I have only a few. Tempe, we normally go in order of seniority on the board, except for me.
Okay,
I get to go before Sherwin and Jack.
I'll wait my turn.
Okay, I didn't want you to, okay. At two places in your well-written and persuasive statement, you say the encroachment, if it does exist, and in the next paragraph, if an encroachment into the side yard was created, are you disputing that it exists?
I can't dispute it. I don't have another survey. We have the original survey, which we believe is likely incorrect. It doesn't look like it had the excruciating detail that the new survey had. But for purposes of this hearing, I don't dispute that there's a 1'9" encroachment.
Okay. In the second full paragraph on the second page of your statement, you say that the fact that there have been no complaints or concerns for the last 36 years demonstrates that there is no urgent need or any need at all for the encroachment to be removed. Are there any complaints now from your neighbor that have been communicated to you?
No, and I've spoken to the neighbor. The original owners, Fred and Mildred Leonard, who were good friends of ours, and we got along famously with them. They've both passed, but their two children, one lives in D.C. and the other one lives, I believe, in New Jersey. And I have communicated with both of them and sent them information concerning what's going on, and they have no objection whatsoever.
Thank you. I have no further questions.
Yeah, I was just going to say, their house, by the way, is about, according to where the current survey says the boundary line is, their house is somewhere between 20 and 25 feet from the boundary line.
Sure.
Yes, thank you. One other question is, has there been a renovation since construction, something that would have changed if the footprint?
No. The only thing that's changed since the original construction in '88 was, I think, in '89 or '90 when we had the deck and the screen porch built, but those are on the back of the house. Nothing has been done on the side yard.
Has the house been refinanced? Something that would have gotten another survey.
I'm certain that we refinanced once or twice, but I've never seen another survey. It's never appeared before. And I take your point on a refinance. If they would have wanted a survey and not relied on the old survey, if it would have shown up, then we likely would have been before this board years ago. I mean, there were 36 years, so.
Thank you.
Mhm.
No questions.
Steve?
Just a question on the exceptional nature of the lot. I wanted to confirm, maybe Susan, you could help, would be, it is irregular shaped, correct?
Yes.
Unique? I wanted to ensure, it's an issue of geometry. Noted too that in the layout of the development, you're on the top corner. of the home, but in the application, you mentioned that this proximity to Assawoman Canal might have had an impact on where the lines were drawn. Could you elaborate on that?
Yeah, had the line been drawn at a greater angle, in other words, as you come back from the street, right now it takes a sharp right turn.
Yeah.
It could have been drawn and then just taken a slight right turn so that Lot 11, our neighbor at 621, would have had a bigger backyard.
Right.
And it could have gone all the way to where the storm drainage easement is at the back end and cut off our access to the Assawoman Canal. So that's why our lot's, I think, a lot bigger as well.
Thank you.
Sure.
Are you aware of any other lots that have the same kind of configuration? I can't really tell exactly from the map.
Yeah, when I looked at the map of the entire, of the Bethany West subdivision, I didn't see any that had this sharp turn with as much land. It looked like what they tried to do, frankly, was to stuff as many lots as they could into the parameters that they had. Mm-hmm. And somehow, when they got here, it's the last lot as you go south in Bethany West that has access to the canal. And I think maybe they felt like it would just make it easier to sell the lot if they did that. It was a long time ago when they subdivided.
Yes, it was.
Yeah.
No, I think my questions have been answered.
Okay. Do you have anything else you would like to say before we proceed to deliberate?
I forgot to say that my wife Annie is here with me today. It might have been mentioned, and I damn well better say that.
Yeah. We recognize that.
Thank you, sir.
Thank you.
Mr. Chairman,
Excuse me.
ask a
yeah.
question of the
Please.
building official. Susan, are you aware of any other lots that might be configured similarly? I'm looking at how unique is this?
I counted, I don't know of any other lots that have exactly 7 sides to it. That's pretty unusual to come across, and I think it's because of the angles of the boundaries of the town that they had to do that. So the one, they had some frontage on, I guess, the Assawoman as well as much as they could. So that's, I think, what caused it.
Thank you.
No questions.
Okay. At this point, we'll close the hearing, and the board will deliberate. As chair of the board, and in accordance with the board's custom, I will proceed first in our deliberations to review the legal standards we apply in deciding applications for dimensional variances and to offer my initial views. We will then hear from each of the other board members in order of seniority. Applicant seeks a variance from the side setback contained in Chapter 425 zoning, Appendix 3, Table of Dimensional Requirements, side yard setback for an existing encroachment of 1.9 feet. Under Section 425-105D of the Town Code, in considering an application for a variance from a dimensional requirement, the board is directed to consider whether, quote, owing to special conditions, a literal enforcement of the provisions involved would result in an unnecessary hardship or exceptional practical difficulties, close quote. Approval of the variances requires that the board find 4 specific standards are met. The first of those is extraordinary and exceptional conditions pertaining to the particular lot or structure in question. The facts concerning the location of the residents involved are, in my view, extraordinary and exceptional, as is the lot itself. Exhibit 2, the Kaufman survey, shows the foundation location for the western side of the dwelling to be 7.5 feet from Lot 11 at its closest point. In fact, the building was constructed within 5.9 feet at the closest point. This error was not realized by the town when the certificate of occupancy was issued, which found that the building, quote, conforms to the approved plans and specifications on file in the town office and complies with the requirements of the comprehensive zoning code. It was only discovered this year when a new survey was prepared in connection with a contract for sale of the property. In addition to the shape of the property we're talking about, I think that these are extraordinary and exceptional conditions. The second measure is an application of the code to this particular lot or structure would create an injustice. As the applicants described, requiring them to comply at this time with the 7 feet side yard setback would, in my opinion, create a substantial injustice given the small dimension of the encroachment, the builder and the town's failure to recognize it at the time of construction, and the cost of compliance, which would necessitate moving the house or substantial construction alterations to the side of the house, either of which would undoubtedly be expensive. The third criterion is that the conditions are peculiar to the particular piece of property involved. Given the facts, I believe that the conditions involved are peculiar to this property. And lastly, a variance, if granted, would not cause substantial detriment to the public good or impair the purpose or intent of the code. It does not appear that granting the requested variance would cause any detriment to the public good or impair the purpose or intent of the code. The encroachment is small and has not been an issue for over 36 years. In fact, as we've heard, the owners of the adjacent property have not registered any objection to the application. The board must also be mindful of the Delaware Supreme Court's holding in the Quick Check case. In that case, the court articulated 4 factors to be considered. The first was the nature of the zone in which the property lies. In this case, the variance sought relates to a residence in a residential zone, so it appears that this standard is satisfied. The character of the immediate vicinity and uses contained therein. The variance sought to allow the existing residence to remain, as it has been for many years, would conform to the character of the immediate vicinity and uses. Third, whether if the setback restrictions were removed, it would seriously affect neighboring properties. The effect of granting the requested variance would allow minimal encroachment into the code setbacks requirements, which would not seriously affect neighboring properties. The encroachment's existence for 36 years and the lack of any opposition from the adjacent property owners clearly support that conclusion. Finally, the Quick Check decision inquires as to whether, if the restriction is not removed, it would create exceptional practical difficulty for the owner to make normal improvements. And in that regard, the board should take into consideration whether, If the restriction upon applicant's property were removed, such removal would seriously affect neighboring property and uses, and whether, if the restriction is not removed, the restriction would cause unnecessary hardship or exceptional practical difficulty for the owner in relation to his efforts to make normal improvements in the character of that use of the property, which is a permitted use. I believe this balancing of the effect upon neighboring properties of granting the variance and the creation of an unnecessary hardship or exceptional practical difficulties for the owners of the subject property if the variance were denied clearly supports granting the requested variance in this case. Sherwin?
Thank you, Mike. I agree with your conclusion. If this was a mistake made long ago, nobody's fault who's here now, and I believe not granting with the variance would place unnecessary hardship on the sellers and the buyers. I voted for granting the variance. Thank you.
I agree with the chairman's summary. As to the property, I think two of the keys are it's certainly an unusual property to have in Bethany. And as far as the hardship goes, apparently they can't sell this property with this hanging over its head. And the longer we wait on establishing that, the more pressure or hardship will go to the people. It's certainly particular to this property as to what the occurrence was, especially back in 1987. And in looking at it, there are no objections from the neighbors, and it's certainly not against the public good in order to make such a change. So I am in total agreement with accepting the request of the applicants on this issue.
Steve?
Thank you. I agree with the chairman's conclusion. From an extraordinary and exceptional condition, this is a irregular shaped lot. It's an issue of geometry. And it's not a typical lot in Bethany Beach or, in this neighborhood. In terms of the application of this code, this issue was created in 1988, and requiring a correction today would be would create an injustice. I think about having to move the house and the environmental impact that would be associated with it. In terms of conditions or the peculiar to the piece of the property involved, yes, this is irregular. We think this has been created from the proximity to Assawoman Canal. And considering those circumstances, I think that's satisfied. And then variance of granted would not cause substantial detriment to public good. There were no complaints or concerns in the last 36 years, and no one here to provide testimony. So in conclusion, I vote in favor of granting the variance.
Thank you. I'll start with the conclusion and work backwards.
Sure.
I agreed to grant the variance. For all of the reasons that you all have said, what really stuck with me was the unusual shape and location of the lot. It's not only unusual, it's maybe unique. It's been there a long time. Nobody's complained. I know we're not to speak to our own experiences, but things have changed in the enforcement of the code since 1988. And the fact that these folks had to have a survey, lost a contract, hopefully have gained a contract, is testimony to the detriment that they have suffered already, although not for 30-some years. It seems rather obvious that the harm to the applicant is much greater than any harm to the town or to the code. We all have some sense of what the cost of replacement or moving it would be compared to living with an encroachment of 21 inches. So I'm in favor of this variance.
Okay. Does anyone have a motion that we vote to approve the applicant's request for variance?
I move that we approve the applicant's request for a variance on the property.
Second. Mr. Boyce has seconded. All in favor, please raise your hand and say aye.
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 All are in favor, none are opposed. I'd like to address this to my fellow board members. Our rules allow us, in a situation where we have a verbatim transcript, to treat that as the final decision of the board without issuance of a separate written decision. I think in this instance, it would expedite it if we followed that procedure. And I would just like to know if the other board members are amenable to following that approach here.
I agree with that approach, and it's totally legal and above board.
And I think that's an appropriate thing to do in this particular application.
Okay.
I agree.
Second. Yeah.
All right. That's what we will do then, and we will endeavor to expedite preparation of the transcript.
Do we have to vote on that?
No. And with that, this hearing is concluded at 2:35.
Amazing.
What?
Amazing.
Thank you.
Thank you.
You're welcome. Very justified.